The Fifth Circuit recently ruled that suppressors are not arms and therefore do not trigger 2A protections. However, now that decision is heading to the Fifth Circuit en banc panel in the hopes to strike down those suppressor restrictions and that improper analysis. So let's break down what is happening. Now, really quick before we jump into this video, I want to ask you guys for a favor. Looking at some of my analytics, about 58 to 60% of all viewers are not subscribed to the channel. So if you want to support the channel for free, please consider subscribing. By no means do you have to. It's just something you can do if you want to support the channel. And then also just drop a comment down below, a positive comment, because that helps to tell the algorithm that not only do you see value in this video, but all 2A content, so it will surface my video and other people's videos to you guys and to other individuals. As I mentioned in the intro, in this video, we're going to be discussing the suppressor challenge that was recently ruled on by a 3-judge panel in the Fifth Circuit. This case deals with the constitutionality of the NFA as it applies to suppressors. The case is called US versus Peterson, and this is a very critical decision and a very critical case that is now seeking en banc panel review in the Fifth Circuit. This case involves an individual who had a gun store at his home that was raided by the ATF. And during the raid, the ATF found a single solvent trap that was not registered or serialized. And because of that one item, Mr. Peterson was charged with violating the NFA. Mr. Peterson and his attorney tried to get that charge thrown out with a motion to dismiss, and they argued that the NFA is unconstitutional under the Second Amendment because suppressors are protected arms, and this regulation in the federal aspect is a violation of 2A rights because it's restricting the access to bearable arms. The district court denied that motion, finding that silencers are not bearable arms protected at all by the Second Amendment. That decision was reviewed by a 3-judge panel in the Fifth Circuit, and ultimately they agreed that suppressors are not protected arms. However, now this case has been filed to the Fifth Circuit en banc panel. They are seeking review of this, and the panel just requested that the federal government respond to this petition for a rehearing en banc, and they need to respond to it by March 17th. This now sets up a very critical challenge to the constitutionality of suppressor restrictions. Now, in this case, back in 2022, both federal and state law enforcement officers executed search warrants at Mr. Peterson's home in Louisiana. The local sheriff executed a search warrant and an arrest warrant based on some delinquent parish sales taxes. So there was some sales taxes that were outstanding. So that's why local law enforcement got involved. But also there was a federal task force, which included ATF agents and about 50 other law enforcement officers who executed that search warrant. The federal search warrant was based on the issues with Mr. Peterson's operation of a gun store out of his home. Specifically, the ATF alleged that there were straw purchases, improper record keeping on 4473 forms, failure to complete and forward multiple purchase transfer forms to the ATF, and then also some issues relating to products that were sold by Mr. Peterson at that store that later, were found at crime scenes. According to the ATF in their brief, the ATF claims that they traced about 70 firearms that were sold by Mr. Peterson that were then recovered at crime scenes. Now, during this raid, federal agents seized his entire inventory, which included about 300 firearms and also all of his personal firearms. But out of this entire incident, the one thing that led to this lawsuit and led to the charge was the possession of a single solvent trap that was found in his home. It was in his bedroom in his own personal safe. Now, in response to that charge, Mr. Peterson filed a motion to dismiss the charge based on the Second Amendment. And on review, the court there denied the motion to dismiss, and they found in their eyes that suppressors are not protected arms, so they dismissed and they did not agree with the Second Amendment claim. That then led Mr. Peterson to then appeal to the Fifth Circuit for reversal. The question the Fifth Circuit 3-judge panel considered was whether the district court erred in finding that silencers are not bearable arms covered by the Second Amendment, or even if so, whether Mr. Peterson's indictment for possessing an unregistered silencer violated the Second Amendment. In the ATF's brief, they first argued that suppressors are not arms protected by the text of the Second Amendment at all. They believe that the district court got their determination right and that the Fifth Circuit should ultimately agree. And at best, the ATF claimed that these are simply accessories, and as accessories, they are not protected. Now, on review, the Fifth Circuit 3-judge panel sided with the ATF, finding that Mr. Peterson's motions were properly rejected by the lower court, and they believe also that suppressors are not protected arms. In their ruling, the Fifth Circuit states that Peterson first challenges the district court's denial of his motion to dismiss. Specifically, he argues that the NFA's suppressor registration requirement unconstitutionally burdens the Second Amendment rights. But because we conclude that suppressors are not arms within the Second Amendment's purview, we disagree. They went on to state that whether suppressors constitute arms is an issue of first impression in our circuit. And so far as we can tell, every court to have addressed it has decided the question in the negative. Here, the Fifth Circuit looks at whether a suppressor is a weapon of offense or an armor of defense, or is used to cast at or strike at another. And here, the Fifth Circuit incorrectly found that they are not. They state in the opinion that Peterson posits that suppressors are an integral part of a firearm and therefore warrant Second Amendment protection. They state, but that is wrong. A suppressor by itself is not a weapon. Without being attached to a firearm, it would not be of much use for self-defense. And unless a suppressor itself is thrown, it cannot be used to cast or strike at someone. Whether a suppressor might prove useful to one to cast or strike at another, that usefulness does not transform a gas dissipator into a bullet caster. Instead, we agree with the 10th Circuit that a suppressor is a firearm accessory, not a weapon. And while possession of a firearm themselves is covered by the plain text of the Second Amendment, possession of a firearm's accessory is not. The Fifth Circuit then went on to find that a suppressor is not a necessary accoutrement of a firearm that is required to make the firearm useful or functional. And based on that, they upheld the district court's dismissal, and ultimately they upheld the decision that suppressors are not bearable arms. Now, this inherently is a very concerning decision. The fact that the Fifth Circuit 3-judge panel found that suppressors are not necessary and that they're merely an accessory brings into question what other accessories or accoutrements that a court could deem are also not protected. But now this case has been elevated to the Fifth Circuit en banc panel. In the petition for rehearing, Mr. Peterson's new counsel argues that the Supreme Court precedent states very clearly that an arm includes anything that a man wears for his defense or takes into his hands or uses in wrath to cast at or strike at another. The important operative word there in that Supreme Court precedent and definition of what an arm is anything. The Fifth Circuit took the categorical approach that all accessories are not protected, but the Supreme Court has not made that statement at all. They have not made a carve out for accessories. Instead, the definition they use is anything. The precedent shows that anything and all instruments that constitute bearable arms are in fact protected. Items like suppressors fall squarely within that broad language of anything and all instruments. They go on to state that if the Second Amendment is to mean anything, then an arm must include not just complete firearms, but also component parts that function integrally with the firearm itself. Of course, the panel was right that a suppressor by itself is not capable of expelling a projectile. But then they state, but no part of a firearm can by itself expel a projectile or do any casting or striking. A functioning firearm is a collection of component parts. They then state that that makes good sense. After all, if a suppressor were simply metal tubes not capable of functioning with firearms, it would make little sense for the NFA to regulate suppressors through a registration regime. They then also state that it's notable that the federal law explicitly labels suppressors as firearms. So now this issue of whether suppressors are protected under the Second Amendment and whether or not the NFA violates the Second Amendment through its restrictions on suppressors is in front of the Fifth Circuit en banc panel. The Fifth Circuit en banc panel has now requested that the federal government here respond to this petition by March 17th. This also becomes even more interesting and very important because the new administration is now in charge. The Trump administration has control of this case. There's the new ATF director, Kash Patel. The Attorney General, Pam Bondi, also has control of this case. And there's the executive order to protect the Second Amendment and the Second Amendment rights. That is out there pending now. The plan and the report is going to be submitted by AG Bondi to Trump, and something like this would probably be also included in that plan because all these cases that were litigated by the Biden administration and defended by the Biden administration, those have to be in the report, and there has to be a game plan going forward about how they want to address this issue. So this is a very important case and an unfortunate decision that was issued by the 3-judge panel in the Fifth Circuit. There's other circuit courts that pre-Bruin had ruled a similar way, but now we need this critical case to be elevated to the Fifth Circuit en banc panel and hopefully get a decision that states that yes, suppressors are protected arms and that these restrictions are unconstitutional. That would also be very important because then it would set up a very critical circuit split for this type of issue to then be elevated to the Supreme Court, to be intriguing to the Supreme Court, because not only then would it deal with a constitutional issue relating to the Second Amendment, but then you would have a very critical circuit split to then get the Supreme Court involved. So again, a very important suppressor case that we're gonna be keeping our eyes on, and as we get more information, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. But as always, thank you all for watching. Don't forget to like, and comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.